states are already introducing legislation to make it harder for divorces to be filed and or granted. And this is in line with the post I made about some Texas legislation that went viral earlier this year. This is for Indiana specifically. Now, I know lots of states are passing through lots of bills or proposed bills at the beginning of their legislative session, but this one is specifically House Bill number 168. So Indiana House Bill number 1684. It was introduced on the 15th of January 2025 by Republican Representative Timothy Wesco, and it has had a first reading in this legislation already as of 1/21/25. So first reading, there's usually several readings. There's usually a chance for commentary. It usually goes into committee. So this is kind of step 2 in the process once it's introduced, and then there's a first reading of it. Other states might do it a little bit differently, but this is specifically for Indiana. So the interesting part about this one is if it's for irretrievable breakdown of marriage, which is kind of one of the causes that you'll see people file for divorce under. And this is specifically addressing irretrievable breakdown of marriage. It provides that if the parties to a petition for dissolution of marriage are the parents of one or more minor children for whom the parties have legal and physical custody, and the sole ground of dissolution of the marriage asserted in the petition is irretrievable breakdown of the marriage, a court may enter a dissolution decree only if, 1, at least one party to the petition presents a witness at the final hearing on the petition who testifies to affirm the irretrievable breakdown of the marriage, or 2, the parties can show causes as to why the petition should be granted. Now, there are some interesting details in this because we know the devil is in the details. So I am actually reading directly from the House Bill number 1684 documentation that's filed in the state of Indiana's website. So there's a whole bunch of stuff here. So I'm going to kind of summarize. I would encourage you all to read the full bill, but basically what it is, it's amending the Indiana Code concerning family law and juvenile law. So it's an amendment to an existing section in the Indiana Code, and it would be effective July 1 of 2025. So this is January when I'm recording this. It would take effect in July, assuming it makes it through committee and would become an accepted amendment. So basically it went from being you can petition for divorce on the basically the cause of it being, you know, how do they term it? Irretrievable breakdown of the marriage. You could just file for that. You would go through your normal divorce process and it would be granted. So now, instead of that, so here's basically what can happen. So the court can enter a dissolution decree with respect to petition for dissolution of marriage only if one party presents a witness to the final hearing to affirm the irretrievable breakdown of the marriage. Okay, so here's the deal though. You can't just bring anybody to be your witness to this. And think about who files most often and the burden of them having to bring a witness in to get their divorce granted. So here are the people who would be allowed to serve as a witness to the party filing under this section. The officiant of the marriage. The person who married you can come as a witness to testify that your marriage is irrevocably broken. An individual who was a signed witness to the marriage. So who signed your marriage license? I don't even remember who had signed mine. A parent or sibling of the party, a friend of the party who has known the party for at least 60 days, a religious leader with knowledge of the marriage, a licensed counselor with knowledge of the marriage, but other than a counselor, anybody that's received payment can't be your witness. So here's who cannot be accepted for purposes of your witness. An attorney. So an attorney representing a party to the petition for dissolution, they cannot serve as your witness. And also an individual described in subsection C1, which was the officiant, the witness. Those people, if they've received any form of compensation for acting as a witness in the final hearing, they don't qualify. So final hearing required, which in some cases I know divorces don't even have a final hearing. They're just, it's kind of paperwork that's settled, it's done, it's signed off on. So this would require a final hearing. And here's the interesting part about this. If the court finds that the material allegations of the petition are true, here's what the court can do. They can enter a dissolution decree as provided in section 16, which is what we just went over. But if the court finds that there is a reasonable possibility of reconciliation, it may continue the matter and order the parties to seek reconciliation through any available counseling. Okay. So they can say, nope, sorry, we don't really think it's broken, but we're going to order you to do counseling. So we're going to do a continuance. We're not going to issue your divorce. We're going to delay it. Here it says 45 days. So for 45 days after the date of continuance, either party can move for dissolution of the marriage, or the court may enter a dissolution decree as provided in section 16. Here's the kicker. So you go to court, the judge says, I'm going to do a continuance on this for 45 days. If no motion for dissolution is filed, so if you don't follow up and refile a motion for dissolution, the matter shall be automatically and without further action by the court dismissed after the expiration of 90 days from the date of continuance. Okay, so a couple of important things here. There's a whole bunch in here. There's a couple more key points, but essentially it is, if you want a divorce now in the state of Indiana and you have minor children that are in your custody, you have to have a final hearing and you have to have a witness saying that it's irrevocably broken. Even with a witness, the court doesn't have to agree that they think your marriage is irretrievably broken. They can issue a continuance for 45 days and require that you have counseling. Okay, in that time, you have to refile that with, I'm assuming, additional evidence, it doesn't say in here, that it is irretrievably broken, and get it granted. If you don't refile for that petition, after 90 days from the continuance, it's dismissed, which means you'd have to start the process all over again. Again, this is directly from the House Bill number 1684, State of Indiana. This is what's coming. I'm going to let you do research. I host the Divorce Curious podcast. So if you're wondering, why do I care? What do I have in it? That's why. So this is for anybody who's considering getting married or anybody that may be considering getting divorced. It's not the law yet. It's just a bill, just an amendment to an existing code, but it could take effect as early as July of 2025 if it goes through the process and everything passes. I'm going to try to get an attorney on the Divorce Curious podcast here from the state of Indiana, a divorce attorney that can speak further to this and give us kind of the ins and outs of how this is going to impact the divorce process. But my takeaway, my summary is that it's going to start getting harder to get divorced. It's going to be more arbitrarily decided if you have like just cause or if they agree that your marriage is irretrievably broken. What happens if they don't? If you don't get the divorce you're seeking granted, and it extends kind of the runway for having a divorce processed and a decree issued. So again, I expect to see many more states joining in amendments that impact family law. What are you seeing in your states? We know about the one in Texas. I've already done a video on that. I'm really curious what other states are seeing coming through in House bills or Senate bills, specifically related to marriage, divorce, or custody. Let me know. Put it in the comments.